Hi everybody, I'm John Mulhall. Welcome to another installment of Divorce DL. I'm joined today by my good friend Robin Bresky, who is an appellate lawyer practicing with the law offices of Robin Bresky, based in Boca Raton, with an office in West Palm Beach and an office by appointment in Miami. And Robin and her lawyers are soon to be my neighbors here on the third floor of the Bank of America building in Boca Raton. So I want to welcome Robin today.
Thank you. It's nice to be here.
So Robin and I have known each other over the years. Certainly, I know that as part of Robin's appellate practice, she has occasion to handle appeals in family law cases. And we were talking, and we thought, what a great opportunity to bring Robin on and try to help some of us family lawyers tackle issues that may relate to appeals in our family law cases.
Terrific.
So, and while certainly, no practitioner, looks with enthusiasm on the prospect of having to either appeal an adverse decision in a divorce or defend one, certainly they will happen from time to time, and at that point in time, it's important to bring in an appellate practitioner, correct?
Sure. In fact, you can even bring in an appellate practitioner before an appeal is needed, and sometimes if you think it's going to be headed to an appeal in a very contentious case, or in a case with a large amount of monies at stake, or very important issues, it is worthwhile to bring in an appellate attorney to preserve the record during the trial and to potentially help with litigation support and matters such as complex litigation matters and issues of first impression as well.
Well, so we all know that when we try cases, we're introducing evidence, we're introducing testimony, and there is a court reporter. There should be a court reporter, correct? Always should be a court reporter.
Always.
Plenty of appeals. Yes. Do not win or do not go forward.
Have a court reporter.
Always have it reported. If it's worth saying, it's worth reporting.
That's right.
But certainly we know we're trying to create a record. So your advice would be in proper cases or in important cases that actually consultation with the appellate expert probably would be a good idea as you're getting ready to prepare the record.
Sure. As you're getting ready to prepare your case as well, and even to bring it back to the beginning, getting ready to go forward with even potential issues of discovery, if not that early, at least at the trial. Because at the trial is when, if the record is not preserved, in other words, an objection is made, and if it's not properly objected to, or even if you don't get the judge to create or to answer with a ruling and make a ruling on an objection, you may have not preserved the record for appeal on that issue. So it's very important, because it's hard when you're the trial attorney and there's so many things going on. It's very difficult to strategize. Things come up, as you're moving along, and also always think about preserving that record.
So not doing something out of concern for upsetting the judge or making the proceedings perhaps a little bit longer can really be a decision that could imperil a worthy issue on appeal.
Absolutely. In fact, last year I had a trial attorney hire me, and it was just not going well with the judge. And she said, when I said, you need to object, and I was sort of sitting there whispering in her ear, she said, why? He's just going to deny it. And I said, well, that's why I'm here,
That's right.
Because it doesn't matter, because we want that issue for appeal. So that sometimes you do want to make the judge happy, or you don't want to upset the judge, but it's very important to make your record. And the trial attorney can always say, Judge, I need to make this objection for the record.
There you go.
And then the judge, understands.
So make objections to preserve your appellate rights. What other tips would you give to lawyers who are trying their divorce cases, or just got a decision from the judge that they're not happy with, either during the proceedings or at the end of the case? What types of things should lawyers be aware of?
Well, I would say at the end of the case, if you get an opinion, once it's a written opinion, definitely if you think this is an issue that's going on appeal, consult an appellate attorney immediately, because once you have a final opinion and a final appealable order, you have 30 days to do a notice of appeal, but you have only 15 days to do a rehearing. And we find it's very helpful if the attorney will come to us or the client comes to us before that motion for rehearing period elapses, so we can review the record and we can decide what we want to raise in the rehearing. There are certain issues that you need to raise in the rehearing. If the judge hasn't stated the best interest of the child pursuant to the statute, there are certain issues that you waive on appeal if you don't bring them up in a rehearing. Okay. So it's really important to consult an appellate attorney on a motion for rehearing.
Now, and I'd have to say, I probably know, enough about appeals maybe to be a little bit dangerous, but certainly in some cases I see lawyers who will apply for rehearing in the middle of a case to an order that's not a final judgment, etc. Is that the right thing to do? If you're not happy with a particular temporary order or discovery order, is filing a motion for rehearing a wise thing to do at that point?
Well, first of all, we kind of use the terms rehearing and reconsideration interchangeably, but the trial attorney is actually filing a motion for reconsideration of a non-final order. A rehearing is only directed to a final order. So a motion for reconsideration can certainly be filed and can certainly ask the judge to re-look at this, because before a final judgment, the judge can change his or her mind on basically any issue. So yes, it's fine to ask for a motion for reconsideration or to make one and to argue it. However, that does not toll the time for an appeal.
So when you say toll, in terms of you don't get more time to file your appeal just because you filed a motion for reconsideration?
Correct. For example, a motion for rehearing at the end of the case will toll your time. So you make a motion for rehearing. If it's an authorized timely motion within those 15 days, then you have 30 days from the time the order on the rehearing comes out. Even if it's a denial of the rehearing, you have 30 days to do the appeal. In a motion for reconsideration that's directed to an interim order or a non-final order, or sometimes called an interlocutory order, you only have 15 days. I'm sorry, you still have 15 days to make that motion for reconsideration, but it does not toll your time for appeal. So if you want to do an appeal from an interim order, you need to do it within 30 days of the date that order is rendered. And for purposes of rendering, we mean filed with the clerk's office and date stamped with the clerk's office. That's when the time actually begins to run.
Okay. And in terms of hiring the appellate lawyer, is the appellate lawyer able to make arguments that were not made before the trial judge? I mean, if you see something that should have been argued, are you at liberty in the appeal then to point out to the appellate court, well, this is something that should have been raised but was not?
No, not in the appeal. It is not a second bite at the apple. It is not a chance to make new arguments. The reason being, the purpose of an appeal is to get the higher court to review what, in a family law case, the trial court, the trial judge has ruled. And the only way they can review that case and decide whether or not the trial court made a proper order, a correct order, or an erroneous order is to review what was in front of that judge during the trial and what was in the record at that time. You cannot go outside the record, and it happens a lot when we are dealing with pro se litigants or attorneys on the other side that are not so familiar with the appellate rules. They try to argue something that's not in the record. We do a motion to strike, and that gets kicked out.
Good. Okay. Well, great advice. Thank you, Robin, for joining us here today. So we've all now learned a little bit more on appeals and family law cases. Until next time for Divorce DL, I'm John Mulhall. Thanks for watching.